Hello everyone. This is lecture 9 on the Supreme Court rules. We are discussing Order 8, which provides for documents. Let's begin. Rule 1 provides that the officers of the court shall not receive any pleading, petition, affidavit, or other document except original exhibit and certified copies of public documents, unless it is fairly and legibly written, typewritten, or lithographed in double line spacing on one side of standard petition paper, demi foolscap size, or of the size of 29.7 centimeters into 21 centimeters, or paper which is ordinarily used in the high courts for the purpose. So, if we have to file a pleading, petition, affidavit, or any other documents, these 5 conditions will have to be followed. Otherwise, the registry, the officer of the court, they will deny admittance of such documents. Yes, if I am filing original exhibits या certified copies file कर रहा हूँ of public documents, then they will accept it. Then they will accept it. Now let's see what is rule 2. This is about language, English language and its translation. It reads, no document in language other than English shall be used for the purpose of any proceeding before the court. तो ये बिल्कुल clear हो गया कि if we have to file any paper, it should be in English. If it is in some other language, you cannot file it. ऐसे तो दिक्कत हो जाएगी. We will have to make some way. Alright, so unless it is accompanied by ABC. What? Firstly, if it is accompanied by a translation agreed to by both the parties, or a translation certified to be true translation by a translator appointed by the court, or C, the said document is translated by a translator appointed or approved and notified by the court. So if I am filing a paper which is in any language other than English, then I will have to get it translated. So that translation must be agreed upon by both the parties. Secondly, that translation should have been certified to be true by the translator appointed by the court. And C, that document translated by translator appointed or approved and notified by the court. So it should be agreeable to both the parties, or it should be certified by the translator, or it should be directly translated by the translator. Now there is an explanation appended to it. What does it say? It simply says that there is a document which is in English coupled with some any other local language, or say Hindi or any other local or regional language. Then what? Same thing, get it translated in accordance with this rule 2. That's the explanation. Now let's see what is rule 3. Rule 3 provides that every document required to be translated shall be translated by a translator appointed or approved and notified by the court. So rule 3 says, all right, you have to get it translated, you have to get your documents translated, get it translated through the translator who has been appointed or has been approved and notified by the court. Means we don't have that leverage कि हम किसी से भी जाके translate कराएं. We have to stick to the translator who has been appointed or approved and notified by the Supreme Court. What is the proviso appointed to it? Proviso says, provided that a translation agreed to by both parties or certified to be a true translation by the translator appointed or approved by the court may be accepted. So that we already know. Rule 2 में तो वो already provided है. That we already know it. Alright, now come to rule 4. Rule 4 is simply oath or affirmation by the translator. I have been appointed as a translator by the Supreme Court. Now I will have to take an oath or affirmation about what? That I will translate correctly and accurately all documents given for translation. What does Rule 5 provide for? Rule 5 provides for Presentation. Presentation by whom? Presentation of what? Presentation of all plaints, petitions, applications, and other documents. By whom? By whom? By the plaintiff, petitioner, applicant, appellant, defendant, or respondent in person, or by his duly authorized agent, or by an advocate on record who has been duly appointed for that purpose. There is a proviso attached to it. This proviso specifically provides for production by the indigent person. I have been declared as an indigent person. So you will give me some leverage? कुछ मेरे लिए provisions अलग से होंगे? हाँ, yes, you will be given that. कैसे? क्या मुझे सुप्रीम कोर्ट आना पड़ेगा बार बार? नहीं. What you have to do, if you have to file, what you can do as an indigent person, you may present the document before the judicial authority of the place where the said party, means you, the indigent person, resides. So if I am an indigent person, suppose I stay at Ghaziabad and I cannot move to Delhi. What will I do? I will go to the judicial authority in my city. I will go to the Ghaziabad Civil Court and I will file my petition there itself. Now my work is over as an indigent person. I have presented the petition. Now the duty of the judicial authority will start. What will the authority do? The said judicial authority, after attesting the document and endorsing thereon under his seal and signature the date of presentation, shall transmit the same to the court by registered post, acknowledgement due at the expense of the party concerned. So this judicial authority will have to attest the document, will have to endorse their seal on it and signature along with the date of presentation. And after this, they shall transmit the same to the Supreme Court by registered post. Yes, the acknowledgement due will be on the expense of the indigent person. Then the date of presentation in this court, that is the Supreme Court, of the said document shall be deemed to be the date endorsed thereon by the said judicial authority. What is Rule 6? Rule 6 says presentation at the filing counter. Whenever we have to file these petitions and anything, we all know we go to the filing counter. So it says something about it. Let's read. All plaints, petitions, appeals, or other documents shall be presented at the filing counter and shall, wherever necessary, be accompanied by the documents required under the rules of the court to be filed along with the said plaint, petition or appeal. So, हमें जो भी file करना है, that we will do at the filing counter. Now, this Supreme Court rules, ये हमें कहता है कि all right, in this you are filing an SLP, all right, it has to be followed up with this document. हाँ, तो उसके साथ file कर देंगे. So this is all. What does the proviso says? Proviso says simply when the presentation has not been done at the filing counter, then what? Let's read. Provided that a plaint, petition, or appeal not presented at the filing counter by the petitioner or by his duly authorized advocate on record shall not ordinarily be accepted. Registry will say, all right, you have not presented it at the filing counter. Please, Mr. Lawyer, take it back. We will not accept it. Ordinarily. Now here comes the exception. Unless as directed by the CJI or a judge nominated by the Chief Justice of India for this purpose. What is Rule 2? On receipt of the document, we have filed an SLP before the Supreme Court. We have filed it at the filing counter. Now, what will office do? Office की क्या duties हैं? See, on receipt of the document, the officer in charge of the filing counter shall first endorse on the document the date of receipt. आज मैंने file किया है, then that date will be endorsed upon it. And enter the particulars of the said document in the register of daily filing. Secondly, what he will do? He will enter the particulars of the said document in the register of daily filing. Then thirdly, what he will do? And cause it to be sent to the department concerned for examination. We all know filing hui. After that, this officer in charge will check it. He will endorse it. He will register. He will register it in the daily filing register. After that, he will send it for inspection or scrutiny. So he will send it to the department concerned for examination. And if on a scrutiny of the said document, it is found in order, it shall be duly registered and given a serial number of registration. What is Rule 3? This is about defective document. I have made a filing, I have filed a Article 32 petition. There is some defects. Where a document is found to be defective, the said document shall, after notice to the party filing the same, be placed before the registrar. The registrar may, by an order in writing, decline to receive the document if, in his opinion, the mandatory requirements of the rules are not satisfied. Where, however, the defect noticed is formal, the registrar may allow the party to rectify the same in his presence. But in other cases, he may require the party to obtain an order from the court permitting the party to rectify the same, and for this purpose may allow to the party concerned such time as may be necessary, but not exceeding 28 days in aggregate. So whenever we file a petition and some defect is there, when we get that SMS through our on our registered mobile number, that is notice. Right now I have got the notice. Now the office will place it before the registrar. Now registrar will check it and he will decline to receive the document. When in his opinion the mandatory requirements of the rule are not satisfied, he will decline it. Yes, in case I have filed a say notice of motion and the defect is formal in nature, then what? You will decline? No, you will allow the party to rectify the same in your presence, means the registrar's presence. But what if the defect is not formal in nature? Then he may require the party to obtain an order from the court permitting the party to rectify the same. You will have to get a court order for rectifying some defect which is not formal in nature. And what will be the time span giving for it? It will be such time as may be necessary, but in any case, it will not exceed 28 days in aggregate. Sub Rule 4. Where the party fails to take any steps for the removal of the defect within the time fixed for the same by the registrar may, for reasons to be recorded in writing, decline to register the document. Mr. Advocate, Mr. Party, you were given time for removing the defects, taking steps. You have not done that. Now this is going to be declined and it will be registered in the document register. So the registrar will decline to register the document. What is Sub Rule 5? Any party aggrieved by any order made by the registrar under this rule may, within 15 days of the making of such order, appeal against it to the judge in chambers. We have already read the powers of the judge in chambers. If you remember, there was this provision, so it speaks about that only. If under Rule 6, I am aggrieved by any order passed by the registrar, I can appeal against the same before the judge in chamber within 15 days of the making of such order. Rule 7. The registrar may, on application by the party interested, order the return of a document filed in a suit, appeal, or matter if the person applying therefor delivers in the office a certified copy thereof to be substituted for the original. There was a petition in which I have filed my client's original sale deed. Now I have made an application to substitute it. Yes, you can do it under Rule 7. You will have to move an application before the registrar. Registrar will require you to deliver the office a certified copy of that sale deed, and then it will be substituted with the original sale deed. What is Rule 8? In short, just remember that Rule 8 provides for court fee, its payment, non-payment, and effect thereof. That is all in Rule 8. What is Rule 9? Same, levy and collection of court fees. We need not give it that much of time. So this is all for the video. Thank you for watching and please like, share and subscribe to our channel.